was a deadly weapon in the aggravated assault with a deadly weapon, then the court will enter an affirmative finding of deadly. The court is calling 2022 CR 2790 and 2022 CR 10495, State of Texas versus Keenan Brown. Can I have the parties announced for the record for the state?
Daniel Escobar for the State of Texas.
Defense.
Arlene Gay for the defendant.
All right. And are you Mr. Brown?
No.
Counsel, have you received all the discovery in each case and did you review it with your client?
Yes, all the cases we're pleading on, except for one notation I was told today.
Judge, so on cause number 2022 CR 2790, there was a audio file that was mentioned in the prosecution guide from one of the witnesses. I had reached out to SAPD because we did not have that in our possession. SAPD reached out and said that they didn't have it. They updated me today, and that's when I told defense about it.
It's the conversation is noted.
Yes.
It's just the recording. If there was one ever made, it was not, and they told me, and that's one of the cases he's taken a plea on today.
All right. And knowing that, do you still wish to continue with the plea?
Yes, Your Honor.
And Mr. Brown, do you still wish to continue with the plea? I got it.
Yes, ma'am.
And are there any applications?
No, Your Honor.
And each cause number, I'm going to show you the court will find that the state is in compliance with discovering each cause number. And in each cause number, Mr. Brown, I'm going to show you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
And in the cause number ending in 2790, state, are you proceeding on the indictment as presented?
Your Honor, the state is going to waive the repeat offender enhancement, but otherwise proceeding on the case as presented.
Any objection?
No objection.
Cause number ending in 2790, you're charged with the offense of aggravated assault with a deadly weapon. And the cause number ending in 10495, you're charged with the offense of robbery. Each of those offenses are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? Each of the cause numbers punishment is to be assessed at 5 years in the prison. There are no applications. The cause numbers will run concurrently. The state will take into consideration 2022 CR 2791, 2023 CR 5662. This is to run concurrent with your federal case 22 CR 246. And did you understand that if the court finds that there was a deadly weapon in the aggravated assault with a deadly weapon, then the court will enter an affirmative finding of deadly weapon. Did you understand that? Did you understand that to be your plea bargain agreements in each of the cause numbers? Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
495, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2022 CR 2790, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's pleas?
State offers State Exhibit 1 in both cases. It's different States Exhibit 1s.
No objection.
All right. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking that the court follow the plea bargain, and I'd like to address the documentation of back time in this matter.
Okay. Then in cause number 2022 CR 10459, the court is finding you guilty. Court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 2790. Take in consideration 2022 CR 2791 and 2023 CR 5662. This will run concurrent with federal cause number 22 CR 246 and counting in 2022 CR 2790. The court will follow your agreement, sentence you to 5 years in the prison, give you credit from credit for any time served beginning February 16th, 2022 through today.
Yes, Your Honor.
There's an affirmative finding of a deadly weapon. This will run concurrent with 2022 CR 10495, the federal case 22 CR 246. Take in consideration 2022 CR 2791, 2023 CR 5662. Is there anything else with regards to sentencing in that case?
No, Your Honor.
And we can go off the record. How old are you?
34.
All right, you're 34. And it appears that you determined to spend a lot of time in custody. After this time, you need to sit at the jail, sit at the prison, and think about, why am I here? How did I get here? Do I really want to live my life? Institutionalized. Because if you do, what's going to end up happening is at some point, you're going to be labeled as a habitual offender. And in Texas, when you're a habitual offender, depending on the offense, your minimum starts at 25 years. Do you understand?
Yes, ma'am.
So you're going to have to change your ways. And if you have an anger issue, you need to work on it. All right. Good luck to you. You're welcome. Court is calling 2023 CR 9061, State of Texas versus Christopher Dela Cruz. By parties announced for the record for the state.
Hank Wilkes for the state, Your Honor.
Defense.
And Eric DeWalt, I represent Mr. Dela Cruz.
Are you Mr. Dela Cruz?
Yes, ma'am.
All right. You entered a plea of no contest to count 2 on November 16th. The state waived count 1 and the enhancement allegation without objection. The court found there was sufficient evidence to find you guilty. According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison, and the state is opposed to your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right. Are any objections to the PSI report, state?
No, Your Honor.
Defense?
None, Your Honor.
Any objections to the TAP evaluation, state?
No, Your Honor.
Defense?
No, Your Honor.
All right. Any witnesses, state?
No, Your Honor.
Defense? Any witnesses?
Just,
All right. Then the court will hear argument. State your opposed.
Yes, Your Honor. Based on the defendant's criminal history, he's already got a shot at probation in 2019, Judge, that he was unsuccessful on. So we feel like it would be a disservice to the defendant to give him the probation. We don't feel like he's a good candidate for
You can come around.
We don't feel he'll be successful on probation. And also the amount of drugs on his person, it's not a less than a gram case, Judge. So based on the defendant's criminal history and the incident offense, we're opposed to the application for probation, Your Honor.
this is a 12-month application, a right of appeal. We don't have a right to appeal. We had talked about this. I didn't have you sign it. No, it's not.
So on page 8 of the TAP, Judge, at the bottom there, it says, I'm not a thief, but to maintain my drug habit, I sell heroin and methamphetamine. So, Your Honor, this is not someone who has a substance abuse issue. This is not a drug user. This is a drug dealer. So, you know, incarceration is for folks that we're scared of, not people we're mad at. And if we're, kind of mad at people who have a drug problem, like, hey, get some help, this would be somebody that is more scary to me, Judge. A drug dealer, I think that's a scarier thing, Judge. So that's why we're asking for incarceration rather than probation, Judge.
All right.
Your Honor, if I may, I've represented my client for some time, and I've never had a client more easy to talk to. He understands he's in front of the court, and he understands he's facing prison time. But in talking with him ad nauseum, he is asking the court for one chance. We're not doubting anything the state just said. He has had a chance at a state jail felony before, and he messed that up. The state waived a repeater and waived count one, which allows him an opportunity for probation. I believe what he said to the officer was, "I'm not a thief," because the car that he was driving was not stolen. It just didn't have a registration. And he wanted to let him know that he is battling drug addiction. The recommendation of the TAP is for full SATF. And I've talked to my client. He knows that if he doesn't change his life right now, he'll never change his life. It's a constant battle. Yeah, I've read through his history. He kind of grew up without a father. He helped his mother when he could, or when he wasn't battling addiction. He wished he would have helped her more. He is asking for that one chance of a big, high uphill climb to sobriety. And I believe everybody in their life needs to constantly try. I don't believe he was saying that he's a drug dealer, and the fact that I'm scaring the community. It was, I'm a drug dealer because I'm supporting my habit, which is just as horrible. But he is asking for that one chance. But he is in front of the court knowing you can go either way. And when I talk to him, he's ready for your decision. But I know he's asking for that chance of SATF.
Okay. So I always keep an open mind about everything. And there are some people that come before me with major criminal history, and I've given them probation before. But I know that you've been given a chance with your sobriety before. And you know how I know that? Because it says here that you were placed on probation July 4th, 2019. That means that I placed you on probation.
Yes, ma'am.
And on that probation, an MTR was filed. I denied it and continued you on probation and extended you so you could get to help.
Yes, ma'am.
So sometimes when I see people with major criminal history and I just see them going to prison over and over, or going to the Bexar County Jail over and over, I know maybe nobody's ever offered them help for their drug addiction or whatever is going on. But in your case, I know that help was offered because you're on probation out of this court for possession less than a gram.
Yes, ma'am.
Right. So with that being said, I'm going to deny your application. As previously stated, I'm finding you guilty. If you would like, I can request that you be referred to the therapeutic community. The therapeutic community doesn't increase your stay at the jail. Your stay at the prison. It perhaps can help you with any drug addictions you may have or get you on the right path. I can't force them to place you in it. All I can do is request it. But if you don't ask for it, they're definitely not going to consider it. Do you understand?
Yes, ma'am.
So would you like me to request the therapeutic community for you?
Yes, ma'am, please.
All right. So I'm going to find you guilty. There's a restitution of $177 to SAPD for drug testing. Credit for any time served. I'm going to order the therapeutic community and sentence you to 5 years in the prison. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. We can go off the record. Mr. Dela Cruz, I want to let you know, coming to this decision was difficult because I've worked with people before and had clients before who sell drugs in order to maintain their habit. So I understand that. And I took that in consideration. But you can still change your life. I always tell people, I know anytime you're doing custody, even an hour is a lot of time. but you're going to have to change your ways. Otherwise, you're going to be in and out of the prisons. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you, Your Honor.
You're welcome.